Hi, I'm Emily Rourke with the Bryant Law Center. We practice in Paducah and Louisville, Kentucky in auto accidents and liability cases. Today, I want to talk to you about 6 liability factors that I have a lot of clients ask me about.
Determining whether the defendant is liable for your auto accident injuries is the first and most important factor to evaluate when assessing your personal injury claim. For most auto accident claims, this involves looking at all the following factors. How badly damaged were the auto vehicles involved? Did all of the drivers involved give statements to the police? Were there any witnesses to the accident? Were there any that were involved in the accident that had alcohol levels? How was the driving conditions at the time of the collision? Did both vehicles have functioning headlights, taillights, and turn signals? And finally, are there any defenses? For example, even though the defendant may have made an improper left turn in front of you, were you speeding? Let's look at 6 common types of accidents and focus in on some very specific additional factors that will come into play in determining whether the driver was at fault or liable for the collision. 1. Rear-end collisions. Rear-end collisions are no doubt the most common type of auto accidents. Most of them occur when the stopped vehicle is waiting in traffic, waiting to turn left or right, or waiting for a light to change. The police report will frequently place fault in the moving vehicle, usually for following too close or for inattentiveness. The driver of the moving vehicle will often admit liability at the scene to the police officer, to you, or to other witnesses. Keep in mind that insurance companies usually pay considerable attention to police reports. However, sometimes carriers or their defense attorneys will claim no liability due to sudden and unexpected stopping, failure to signal when stopping to turn, not yielding before pulling into traffic, or a brake defect. An experienced injury lawyer will want to learn about the following specific facts when assessing the certainty of liability in your rear-end collision: vehicle position, the other driver's speed, the other driver's following distance, and your use of turn signals. Number 2, intersection accidents. For the following reason, it can be difficult to prove liability in intersection collisions and failure to yield to incoming traffic that causes accidents. A shifting story. Sometimes there's a lack of consistency between what the driver says, between the original statement to the police and the statement given to the insurance company. Another incident is the absence of witnesses. If there was no independent witnesses, it can become a finger-pointing contest, which will be won or lost based purely on the credibility of the drivers. Again, detailed rules of the road. Sometimes the rules of the road are not easy to apply when the driver's stories shift. An artful defense can be presented to throw a wrench into the case, such as that the lines on the road were recently repainted, but the old lines were still visible, confusing the drivers. Number 3 is parked or disabled vehicles. A number of factors can make or break your case when you have collided with a parked, stalled, or disabled vehicle, including the reason for the vehicle stopped. Did the vehicle break down? Was it parked because the driver was intoxicated and passed out in the driver's seat? Availability of a better location. Could the driver of the stopped car have found a safer location to stop? Warnings. Were there police barricades or cones making the area, as for some reason, unsafe to stop? The condition of the roadway. Was there a big drop-off when the road meets the berm? Your negligence. Did your phone ring, and were you trying to see who was calling? And lastly, was there a statutory violation? Were you speeding? Did you forget to put your lights on at night after leaving a restaurant? Auto versus pedestrian. The overriding factor in pedestrian cases is whether you were walking in a crosswalk when you were hit. If not, the insurance company and its defense attorney will present a jaywalking defense, and obtaining a favorable settlement or verdict will be very difficult, but not impossible. The following liability factors should be carefully examined. The reason for jaywalking. Was a mugger pursuing you, or were you just impatient to get home? Governing traffic code. The length of the walk signal at the crosswalk. the available light on the street, the visibility of clothing. Were you dressed in all black while walking at night? Witnesses, including other drivers and pedestrians. The driving speed, the driver's knowledge and experience. Weather conditions. Was it foggy or was there a snowstorm obscuring your view? Mechanical defects. Did the car brakes malfunction? Weather conditions. Was it foggy or was there a snowstorm obscuring your view? Mechanical defect. Did the car's brakes malfunction? Impeded view. Were there low-hanging foliage in an adjoining yard blocking the start of the crosswalk? Tardy driver. Was the driver of the striking car late for work at the time of the accident? And whether the victim was a child below a certain age. In many jurisdictions, a child cannot be deemed negligent or comparatively negligent. Auto versus bicyclist. Bicycle riders are generally required to observe the same rules, regulations, and safety standards as car drivers. Stopping at signals, yielding the right-of-way at intersections, and using turn signals are all important for cyclists as motorists. The following liability factors should be examined carefully when assessing an auto versus bicyclist case. Designated riding area for bicyclist, reckless riding, safety equipment worn, police assessment of liability, available light at the scene at the time of the accident, visibility of clothing on the bicyclist, driver, bicyclist, and other witness statements, and degree of injury to the bicyclist. Number 6 is truck accidents. Most truck accidents cause serious injuries because of the weight of the truck and the resulting force and impact. Nevertheless, truck accident cases frequently face severe obstacles to successful resolution. Some of those obstacles include, number 1, experienced and difficult adjusters. Insurers often use their better and tougher adjusters in truck accidents, and those adjusters can take a hard line during settlement negotiations. Number 2, biased witnesses. Witnesses often sympathize with truck drivers. Number 3, dishonest trucking personnel. Trucking companies and drivers sometimes falsify or lose records that could help your case. Number 4, multiple defendants. You will possibly face several opponents, all of whom will be trying to pin some blame on you. And 5 is the passage of time. Investigation must begin promptly in truck accident cases. You'll be at quite a disadvantage if you wait months between the accident and retaining an attorney. Potential areas of liability which should be considered in every truck accident are: was there excessive speed by any vehicle involved? Was there a violation of safety regulations by the trucking company? Did any defective equipment contribute to the accident? Was there visibility issues at the time of the collision? Were any of the drivers involved in the accident inexperienced? Was the truck overloaded? Did improper parking contribute to the accident? Was there any unsafe turn in the road indicating road design that could have been a factor? If you have been in an accident and you have any questions we can answer about your auto accident insurance claim, don't hesitate to call